MSW Media.
The rule of law is not just some lawyer's turn of phrase. It is the very foundation of our democracy. The essence of the rule of law is that like cases are treated alike. That there not be one rule for Democrats and another for Republicans, one rule for the powerful, another for the powerless, one rule for the rich and another for the poor, or different rules depending upon one's race or ethnicity. To serve as Attorney General at this critical time is a calling I am honored and eager to answer.
So now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hey, everybody. Welcome to episode 168 of Clean Up on Aisle 45. It's Wednesday, April 10th, 2024. I'm Allison Gill.
And I'm Pete Struck. We have a lot to cover today, including the latest in the New York Attorney General civil fraud verdict of a $175 million bond debacle involving, of course, the Subprime Car Loan King and the latest flurry of motions to delay the Manhattan District Attorney's election interference hush money trial set for jury selection in just 5 days from now.
Yep. And we also have some updates on the disbarment proceedings for Captain Underpants, Jeff Clark, and John Eastman. And I know Captain Underpants was originally Dershowitz, but I think the title has transferred. I think it's a transferable title, right, Pete?
Oh, absolutely. And Dershowitz, if we ever get to the bottom of seeing what actually comes out of the Epstein visitor logs, will undoubtedly come up with far worse titles, I'm sure. So, yeah, 100%
very
transferable.
True. So we'll talk about him, John Eastman, Rudy's bankruptcy case. There's some stuff going on there. And Biggs and Gosar, two members of Congress from Arizona, getting subpoenas from Arizona prosecutors. We have a Fulton County update, another rebuke of congressional impeachment evidence, and of course, Pete Navarro trying to get a different Supreme Court justice to let him out of the poke. So that's a fascinating little piece of begging on behalf of Mr. Pete. But first, we have some patrons to thank. Thank you to all of our new patrons. You make this show work. We couldn't do it without you. Thank you for supporting independent media. Terrier Logic, Mary Beth Brown, Kristen, Matthew, Margaret Phelan, B. Quinner, Ellen Ivins, Bunny with as Witchblade. I hope I'm saying that right.
Or alternatively, Bunny with a switchblade, but could be either.
Look at you. I'm all with as Witchblade. Bunny with a switchblade makes a lot more sense. Thank you, Pete. This is, when we record really early in the morning, I'm very glad that you're here and that you're 3 hours ahead of me. Because it's just, I've only made a small dent in my coffee. So here we are. We have
good long episode. Polish that off. We'll have plenty of time.
We have internet. Thank you. And Dina. So we appreciate you very, very much. Look forward to seeing you here in just, 10 days in DC, where I know we're going to see a lot of our patrons at the DC Gala, the MSW meetup. We have people flying in from Australia, Pete. It's incredible.
Way. Oh, that's awesome.
I'm so excited to meet everybody and have dinner. And so dinner and drinks are on us, cocktails and mocktails on us. But we have a lot of news to get to today. But we will come back and thank more patrons later in the show. Let's start with what's going on with the New York Attorney General civil fraud trial. That's Tish James. That's the disgorgement of $464 million for all of the decades of fraud at the Trump Organization with McConney and Weisselberg and Trump and Jr. and Eric. And let's talk about what's going on with the bond, okay? Because it's getting out of control. And Pete, you and I talked about this before he gave his bond, before it was even lowered, and then again after it was lowered. I was like, I don't think it's going to have a real hard time coming up with it, right? Because he had a really hard time coming up with E. Jean Carroll's bond, which was just $91.63 million.
Just, right? Just, yeah.
Well, yeah, drop in the bucket compared to the
absolutely,
464.
Right.
I didn't think he was going to be able to do it, but he did it. But now there's problems with it, and I'm really not surprised. As we know, Knight Insurance, like Knigget, Knight, Knight, owned by Trump supporter and Trump donor Don Hankey, the Christmas poo, who's the king of the subprime car loan, failed to include a financial statement when they posted the bond for Donald Trump, which caused the court to reject it. And if you got to see Rachel Maddow on Monday night, she went through the history of this guy and how he's been repoing cars from active duty service members illegally, and how his business set up this thing where they would call you up and pretend to be a flower delivery man or a pizza delivery man to find out where you are and then come illegally repossess your car. Predatory lending to active duty service members. And then he was charging 280% or 262% interest on loans for small businesses, making payments due daily. He was eventually fined almost $50 million back in 2015 for this predatory lending and exorbitant, huge, way high interest rates. And then the SEC was investigating him further. But as soon as Trump got into office, poof, all of the investigations into this guy went away. And that's when this guy lent Trump $300 million to cover properties. So she did a really incredible deep dive on this Hankey fellow. So after he didn't put his financial statement with the bond, they refiled after the court rejected it and included the financial statement. And that's when the New York Attorney General, Tish James, filed her opposition to the bond. She objected to the bond, saying that Knight Insurance apparently doesn't have the cash to back the bond. You usually need about 3 times cash on hand to cover it. Now, further, the Daily Beast got a look at the contract between Trump and Knight Insurance and said that contract said that Knight Insurance would not be responsible for paying the $464 million should Trump lose his appeal, and that Trump would have to pay it and cover it with real estate, which completely defeats the purpose of having somebody back your bond. Now, Don Hankey actually told the press he was surprised at how technical this process is. Gosh, I didn't realize it would be such a big deal.
Well, it's somehow suddenly it's not the same as duping a bunch of 18-year-old privates and PFCs out of their paycheck by scaring them into getting a bad conduct discharge. Yeah, it's a little more technical than that, as it turns out.
Gosh, it seems the court demands all sorts of stuff from you. Who knew? Now, and I think that's just a testament to these rich a-holes not understanding, thinking they're above the law, basically. Now, ProPublica pointed out that Trump argued to the court. Remember when he told the court, I went to 30 different places. Nobody will give me a bond. You have to lower my bond. I shouldn't have to pay a bond. I can't do it. I just can't find the money. Well, apparently, Knight Insurance stepped in and began negotiating with Trump days before the appellate court lowered the bond. And Trump failed to notify the court. Oh, it's okay. You don't have to lower the bond. I'm talking to a guy. Right? That seems like it should be against the rules. If somebody steps in while you're appealing for a lower bond and somebody steps in and says, I gotcha, I feel like you should have to tell the court. Right? But regardless, they lowered the bond and there's still problems. Now the New York Attorney General has asked the court to expand Barbara Jones's role. She's the fiscal monitor over the Trump Organization because she wants to include ex parte meetings with the fiscal monitor, with Barbara Jones, over bond negotiations. And then that's really interesting. And of course, Judge Engoron has set a hearing about the bond fiasco for April 22nd. So everyone's going to have to come into court in front of Judge Engoron, who, is really, hasn't been, put off by Trump's tactics at all so far in this trial. No, he's, just done. It's not going to go well for Trump. Let's just put it that way. But this is interesting to see if they tried to defraud the court. You're committing fraud while you're trying to pay your fine for committing fraud. It's unbelievable.
Yeah, and the point that he would make an affirmative sort of request saying, hey, I can't get this money from anybody, so lower it, while he is literally in the middle of talking to somebody to get that amount of money. And that's not, what came out even earlier before Maddow's piece was the fact that, or she talked about it too, when they looked at typically the people who are granting the bonds charge somewhere between 1, 2, even 3% of the total amount of the bond. And as it turns out, what Trump agreed to pay Knight was a tiny amount to the extent Hankey is saying, well, I guess we probably undercharged him. Which, the question is, okay, so why nobody else out there would get that favorable sort of treatment? 1. 2, what is Hankey getting, if not this insurance money? And 3, if he isn't, doesn't this maybe count as some sort of campaign donation or some sort of benefit that, if you're not charging the industry standard, then what, just because he's a nice guy? This is really a technical process, but I'm gonna cut you a deal. Unlike all these people, again, the junk car loan things that you're extending to, again, literally privates, E1s, E2s making, less than $20,000 a year. You can fleece them, but when it comes to Donald Trump and hundreds of millions of dollars, no, we'll cut you a deal on that. It's
well,
nuts.
you got him off the hook of that SEC. Well, we don't have any confirmation that he got him off the hook, but
and the other thing, and again, you can look it up on the MSNBC website, but Meta did a great job of going through some case studies and examples, and there was one couple who got a loan, and not only was it just an absurd amount of interest, it was like, oh, well, you want to prepay? You want to get out of this? Oh, no. There's a prepay penalty. So I've got you on the hook for this extraordinary amount of interest. And if you find a better lender, somebody who more, in line with reasonable commercial rates, and you try and pay this off early, oh, well, then we're going to hit you with this massive prepayment penalty. So it
was a 268% interest rate on the loan and a prepayment penalty of 30%.
Right. And just that is, again, these are the champions of Donald J. Trump. These are the people willing to come help him, not out of the goodness of their heart, but because they're getting, believe me, Don Hankey is getting something out of this transaction. It is not just his beneficence that is, gracing the Donald Trump in his time of need. That's not what's going on here. And the guy, in my opinion, absolute scumbag, just the lowest of the low. You cannot get, and again, we talked about this for sure on the bonus. We might have talked about it on the regular podcast. I remember when creditors would come after soldiers under my command, trying to fleece them yet further for loans like this, getting involved and saying, hey, you know what? No, they're not going to pay you that much. If you want to, we can go to, in this case, it was right straddling the Tennessee-Kentucky border at Fort Campbell. We can go to the AG's office. You pick wherever it happened to be in Tennessee or Kentucky and talk about whether or not what you're doing is legal. And shockingly enough, 9 times out of 10, they'd work out a deal where they'd let Private Smith, cut his payments and, change the repayment plan so it wasn't so predatory. But that is how this man made his billions, right? I think he's a billionaire.
And this guy is pretending to be a flower delivery person, calling up these active duty service members and finding out where they're at so they can deliver them their free flowers from a secret admirer and then come in and repossessing their cars illegally. It's
awful.
Great guy.
And it's funny you're talking about Judge and Gore, and he's not done though, because while we're still up in New York, let's talk about another letter. This Tish James sent a letter to the court asking for an investigation into the Alan Weisselberg guilty plea, asserting that Weisselberg and Trump may have withheld evidence during the trial. Now, specifically, the New York Attorney General.
They did.
Yes, like everything else, it's all a lie. It is cheating. It is lying. It is not playing by the rules. It is, show me a case where that doesn't and hasn't happened. Show me a case where it showed up on time and paid the fee and didn't have to be pursued for whatever it was. Every single time. Mm-hmm. And in this case, Tish James said, hey, look, I reviewed all of the discovery turned over by Donald Trump and Weisselberg in preparation for trial and the emails between them and the Forbes journalist about the valuation of the Trump triplex saying it was 30,000 square feet. And guess what? They were never handed over. And the New York Attorney General's office asked for Barbara Jones, the fiscal monitor, to review the electronic files collected by the defendant to determine if the documents that weren't produced were in fact in their possession and whether they were produced during discovery. And if they were not, she wants Barbara Jones to determine why not. And she asked the review to be completed within 2 weeks. So, by the end of the month, before June rolls or before May rolls around.
Yeah. So everyone's saying, well, what took her so long to ask for this? Well, she literally had to go through hundreds of thousands of pages of documents to ensure that those emails between, Weisselberg and Trump and Forbes were not handed over, during discovery as they are supposed to be. And she did that. She went through, she said, I did a review of all the documents in discovery. I went through all the Bates numbers. I went through everything. I did, word searches, et cetera, to look for these emails. They aren't there. And if they had been there, boy, you can bet they would be part of this trial. And that Weisselberg wouldn't have been able to get away with what he got away with on the stand when he got away with it. And that is, you can't do that. You can't withhold discovery in a case because it's inculpatory, because it's bad for you. So we'll see what Barbara Jones finds out. The judge hasn't granted this request yet. And once he does, Barbara Jones, if he does, will have 2 weeks to look into this and find out why.
But remember, too, and, we reported earlier that when it came to light that Weisselberg was facing potential criminal exposure and might be in negotiations with the district attorney's office over these criminal perjury charges, and Gorin said, hey, everybody, I need you to tell me right now if you are aware of anything that you need to inform the court about legally or due to, professional ethics responsibilities, and met with a whole lot of, on the defense side, a whole lot of mumbling and, claims of, I can't breach attorney-client privilege or, give you an answer about that. So, this
actually accused him of, using a New York Times article as to impose the disgorgement. Remember?
Right.
Robertson, whatever, Trump's lawyer, was like, I can't believe you're relying on a New York Times article to discuss whether you're going to do falsus in uno, which is to, declare all of Weisselberg's testimony probably not credible. And the judge shot back like, excuse me, like he did, like he was incredulous about this accusation. And he's like, look, I'm asking you for more information, credible information for me to base my decision on. That's why I'm reaching out to you today. So anyway, it's been this way, going back and forth like this with just absolute disrespect for the authority of the court on the part of Donald Trump.
Yeah, and I think we're going to see, I think, something coming out of this beyond Weisselberg going to jail. I think there are some things that the attorneys involved in the matter knew or should have known and were not fully forthcoming about them. And whether or not that results in any sort of civil or criminal charges, I don't know. But I would not be surprised at all if there were bar implications for some of the attorneys involved in this.
And we could be seeing a change in disposition of the perjury case with Alan Weisselberg. And I say that because Alina Habba was just fired from his team, his legal team. And sometimes it's just for, we don't like you anymore, or we want better lawyers. But a lot of times when you switch lawyers, it's because you're switching tactics, legal tactics, and you want like an expert in guilty pleas or an expert in cooperation deals or an expert in not guilty plea, so who knows, but she's been kicked off Weisselberg's team. And the attorney, there's an attorney called Armin Morion replacing her. I don't know anything about that person, but we'll dig into it. And Habba has not been fired from Trump's legal team though. So
no, she's got to stand there behind him, like pursing her lips, and then go on RSB and, Fox News and yammer about how he's been set up and he's doing this for all of us. And he's, being
taking one for the
team. All our sins. Yeah, exactly.
All of the fake billionaires that are fraudsters out there, taking one for all of them. Okay. Anyway, we have a lot more to get to, including just an absolute desperate attempts to delay the Manhattan DA's election interference trial. We've got jury selection starting here in 5 days. We're going to go over all of those different attempts, but we have to take a quick break. Everybody stick around. We'll be right back.
Hey, welcome back. We have more patrons to thank. Carol Morgan, Never Spent, Desha Pinchef, Michael Ann T. Boyd, Randall Scott Cover, Gwendolyn Justice, Stop Fascism, Nancy Van Susteren, Sharon Mattioli, and T. Franklin McCrary. Thank all of you so much for your support of the program, for allowing us to do the work to bring this news to you. Absolutely, you are key members of this team, and thank you all so very much for your support. So while we're up in New York, there's so much in New York. Let's stay there for a hot minute. And this time get an update on the Manhattan District Attorney's election interference hush money trial, where jury selection, get this, Allison, is set to begin just 5 days. Count them, 5, less than a week. So let's start, because there's a bunch of stuff around this trial. Let's start with Trump's second attempt to recuse Judge Merchan from the case. Now, you'll remember he tried this last year, and after an ethics review, Trump's motion for recusal was denied. Now, Trump says in August 2023, his motion to recuse was denied because Trump had only provided hypothetical and speculative information. But now he's confirmed that Merchan's daughter works for a firm that has represented multiple Democrats. Trump says that because these Democrats are using the trial in their fundraising activities, that presents a conflict of interest. He also says that because of the gag order, Trump can't defend himself publicly, although he did come out on Truth Social again and mention the judge's daughter in multiple posts, seemingly using the covers of his recusal motion to go after her. Now, the DA hit back saying, quote, defendant has identified no changed circumstances that warrant revisiting the court's August 11, 2023 order denying defendant's earlier motion for recusal. This court and the Advisory Committee on Judicial Ethics have already determined that such a claim provides no basis for recusal. This daisy chain of innuendos is a far cry from evidence that this court has a, quote, a direct personal, substantial, or pecuniary interest in reaching a particular conclusion, unquote. There's simply nothing new here that would alter this court's prior conclusion that nothing about this proceeding will directly benefit Authentic or this court's family member, let alone this court. Now, those were letters to the court, and the court has since allowed for full briefing on the matter, and both sides have filed their briefs making the same argument. So we'll see what comes. You know what gets me, Allison, on this before we go on, because there's more at this trial. Trump is so concerned about this apparent conflict of interest. Do you know what conflict of interest he's not concerned about? He's not concerned about a particular justice who has before him a matter involving whether or not he is immune for actions taken as president, when that justice's spouse, his self-described best friend, was actually at the January 6th speech given by Trump, where Trump incited the crowd to march down to the Capitol and engage in insurrection. He's not that apparent conflict of interest, not somebody's daughter doing something that has a client that is Democrats, somebody's spouse, a self-styled best friend going to January 6th, sitting on the highest court of the land, not recusing because he doesn't seem to think there's any sort of conflict there. If you're Clarence Thomas, there's no conflict there. You can take all these luxury vacations. You are above reproach. Yeah. You cannot do anything wrong. But when it comes to Trump, you can sit there and see who he likes and he doesn't by, just like Eileen Cannon. He will rage against Merchan and Engoron and, Fonnie Willis and anybody except for those people who he seems to think are doing his bidding. And so consequently, no conflict with Judge Clarence Thomas, no conflict with Judge Eileen Cannon. That's all fine. And clearly, if you want to talk about appearance of bias, let's start at the Supreme Court. But he won't.
No, of course not. I mean, he only says what benefits him from the seat he's sitting in at that moment. And oftentimes those are contradictory things. But yeah, I think that the DA has a good argument here, Pete. I mean, nothing is new. All of this information about the judge's daughter has been public for years. Most of the stuff that she did working with these clients happened well before he filed his first motion for recusal. And that's why I really like it in a court filing when they say, even if, the DA will say, even if you find that Judge Merchan's daughter works for so-and-so and gets paid for this, that is still not a reason for recusal. And that's why situations like this is why I appreciate those kinds of arguments, because back last year, Trump was like, I think she's in the pockets of Democrats. And they're like, you're insinuating, you're speculating. But even if she was doing this, it's still not a thing. It's still not a reason to recuse. So now he's filing it again, of course, just minutes before the trial is supposed to start. And I think that the DA will come out on top here pretty easily. Now, there's tons of other last-ditch attempts, Pete, to delay this trial, including Trump filing a motion to dismiss based on immunity, which the judge has denied. And he's not trying to it's actually not a motion to dismiss the full case. He's just trying to keep certain tweets and things that he has said out of evidence when he was president, saying he enjoys immunity as president. The judge denied that. They say the court finds that the defendant has myriad opportunities to raise the claim of presidential immunity well before March 7th, 2024. And Anna Bauer notes on Twitter that because he finds that Trump's motion is denied as untimely, Justice Merchan says that he need not address the question of whether presidential immunity precludes the introduction of evidence. Like, it does, but I don't even have to talk about that because you're filing this on March 7th, 2024. You're way too late. Again, basically one of Trump's tweets, and Adam Klasfeld pointed this out, that he wanted to keep out of trial based on this immunity claim, is a May 3rd, 2018 tweet from Trump that says, Mr. Cohen, an attorney, received a monthly retainer, not from the campaign and having nothing to do with the campaign, from which he entered into, through reimbursement, a private contract between two parties known as a non-disclosure agreement.
That one tweet has more commas than Trump has used in the entire 4 years of his presidency. But, take that.
And that tweet shows that Trump understands the system of reimbursement and the knowledge of the system of the reimbursement. And I think it'll be a key part of evidence at the trial. And it's allowed in now because he was trying to keep it out on immunity. Now, Trump tried to claim that tweeting that was an official act as president, and that's why it should be immune from scrutiny, I guess. But of course, the judge says an immunity motion filed a month before the trial is too late, so too bad, so sad.
But wait, there's more.
There's so much more.
Trump also filed a motion to delay the trial on the basis of pretrial publicity. The government responded that, quote, the court should deny the defendant's 8th request to adjourn the trial based on pretrial publicity because, 1, publicity is unlikely to recede and an indefinite adjournment is inappropriate, and 2, through voir dire will allow the parties to select an impartial jury, and 3, defendant's own incessant rhetoric is a significant cause of the publicity, and it would be perverse to reward the defendant with an adjournment based on the media attention he's actively seeking, unquote. Again, so keep in mind, this is the 8th after the 1st, 2nd, 3rd, 4th, 5th, 6th, and 7th failed motion. And the court already rejected, just as recently as February 15th, rejected a motion to delay based on pretrial publicity. At that time, what is that, 2 months ago, not quite 2 months ago, ruling that the publicity was unlikely to abate. So there's no reason to grant this new motion filed just 49 days after the court rejected that prior motion. So just insane. But wait, Allison, there's more, right?
Oh, there's more. But I just wanted to say what's hilarious to me is Trump complaining that there's too much publicity around a trial and it needs to be delayed for that. And I love that the obvious, I'm sure as everyone was listening to this, the obvious response is, you're the one causing the publicity, Donald Trump. But I love how the DA lists that third. Here's the 3 reasons to deny this. It's the third thing. It seems like the first, but I feel like that just shows a little bit of nice restraint there by the DA. Next up, here's another thing. Trump issued a subpoena to NBC Universal for materials related to the recent Stormy Daniels documentary. Now, NBC filed a motion to quash the subpoena in its entirety, and Judge Merchan granted their motion. So, nope, you cannot subpoena NBC. So Trump lost this one too. And the judge says Trump's subpoena, first of all, it's too broad and it seeks general discovery. Trump was basically accusing NBC and Stormy Daniels of colluding and conspiring on a release date of the documentary to put it out there right before the trial to prejudice the jury pool and the trial and the proceedings. And the judge said, because that's how, documentaries go super fast like that, Pete. You just make them and put them out whenever you want. The judge said the defendant's claims are purely speculative and unsupported. His subpoena, you would if he had an email between Stormy Daniels and Michael Cohen and the producers at NBC that said, let's get this out right before the trial, even though we don't know when the trial is supposed to start. It's bonkers. But there's purely speculative, these claims from Trump. This is what the judge said. His subpoena and the demands therein are the very definition of a fishing expedition. And even if his bullshit conspiracy was more than speculative, you can't have unfettered access to the notes and materials of a media organization because it violates civil rights laws. So again, there's the even if. Trump also, by the way, filed a motion to lift the gag order, the limited gag order issued by Judge Merchan, and delay the trial while he's appealing that, and to delay the trial while he's trying to get a venue change, stating he's unable to get a fair trial in New York. Now, there were hearings with the appellate court on Monday and Tuesday. The Monday one was during the eclipse. That's where the Trump lawyer, Todd Blanche, argued that Manhattanites were hopelessly biased against Donald Trump and the media coverage is prejudicial against him. The DA argued, sorry, it's too late, again, for this motion for change of venue, and that the publicity is generated by Donald Trump himself. That's on you. The gag order arguments were held Tuesday, the following day, and they lasted a few minutes. And that was for an interim stay of the trial. Now, that was rejected, so they're going to hear about a full stay of the trial, and the briefings are due the day that jury selection begins. I doubt they'll grant it, but that was just a denial of the interim stay. But they denied both. They denied the gag order thing. They denied the fair trial, the change of venue. They denied them both within 10 minutes of finishing arguments on both days. Now Trump is suing Judge Merchan to try to slow the trial down, just like he sued Judge Engoron under Article 78, I believe, New York Attorney General civil fraud trial. He tried it there and failed, so we'll keep an eye on that as well. I don't think it's going anywhere, but just filing after filing after filing to try to delay last minute, and most of these are just coming back denied, you're too late, bro. You can't ask for a change of venue the week before trial. We've been doing this you committed these crimes 8 years ago. It's desperate. It reeks of desperation, Pete.
Yeah, he's absolutely flailing. And keep in mind, these briefs don't write themselves, right? I mean, attorneys and partners and, regular, just lower level attorneys at firms have to write these. And of course, Trump has to pay for all that. Nobody's doing this, for pro bono purposes. So again, all of these fundraisers that he's having down at Mar-a-Lago, or again, the continued fleecing of his base, are just going to these ever increasing, and it is flailing. I mean, it's when squealing like a stuck pig, the old expression goes, the fact being that the pig is stuck, right? I mean, he is getting close to trial. He understands his back is up against the wall. He is getting increasingly desperate. You see just these nonstop filing of motions, which are just summarily being dismissed without exception. And I expect this to continue. Again, if we're hearing these, the full panel at the appellate level in New York, hearing the day jury selection begins about whether or not that these gag order arguments are going to be upheld. I think they're going to find with the interim order and say, nope, absolutely not. But it's just going to create more churn and more opportunity for Trump to falsely claim that somehow he's being persecuted and it's terrible and awful and send me $10 so I can defend myself.
Right.
So with that, though, just breaking as we're taping, we have the jury questions and the instructions that Judge Merchan is going to, and this is a little different. It was at the federal level, when it comes to jury selection, I don't think I experienced anything where it took more than a day. I mean, usually it was fast, a couple hours or less. But they anticipate that this, in New York State is going to take, who knows, maybe a week, maybe even more. But we do have the full set, and the questionnaire includes this question. Have you ever considered yourself a supporter of or belong to any of the following? The QAnon movement, the Proud Boys, the Oath Keepers, the Three Percenters, the Boogaloo Boys, or Antifa. Prospective jurors will also be asked, do you currently follow Donald Trump on any social media site, or have you done so in the past? Have you ever worked or volunteered for any anti-Trump group or organization? Have you ever attended a rally for an anti-Trump group? And then this is a paragraph that will be read to the jurors. And this is like kind of summing or presenting the case in as an overview. Quote, the allegations are, in substance, that Donald Trump falsified business records to conceal an agreement with others to unlawfully influence the 2016 presidential election. Specifically, it is alleged that Donald Trump made or caused false business records to hide the true nature of payments made to Michael Cohen by characterizing them as payment for legal services rendered pursuant to a retainer agreement. The people allege that, in fact, the payments were intended to reimburse Michael Cohen for money he paid to Stephanie Clifford, also known as Stormy Daniels, in the weeks before the presidential election to prevent her from publicly revealing details about a past sexual encounter with Donald Trump. Donald Trump has pleaded not guilty and denies the allegations, unquote. So it is clear that just from that paragraph to be read to the jurors at the beginning, this is completely about election interference. That is the heart of the government's case. That is what they are alleging. That is clear in what's going to be presented to the jurors from jump. And so again, this, by the time after this episode, by the time you hear the next episode, barring any sort of extraordinary thing from the appellate court, jury selection is going to be underway.
Yeah. And interesting, too. You know, we've been long calling this an election interference case. So it's nice to see it presented as such officially. I mean, we knew, but because in many filings, the DA said that that's how he's going to present this. I especially remember when he was trying to get the Access Hollywood tape in, and not necessarily to make Donald Trump look bad, you know, as a bad past act, which you can't bring into trial as evidence, but more as a reason, a motive. For why he would want to cover up the Stormy Daniels thing, because it was the same week that the Access Hollywood tape came out that this was going to go. And that snowball effect, you know, how sometimes the whole is greater than the sum of its parts, could have tanked his campaign. Where the Access Hollywood tape alone almost did, but, you know, the campaign survived. But would it have survived a 1-2 punch? So when the DA asked to bring in the Access Hollywood tape for that purpose, the judge actually kept the tape out, but said that he can use the description of the tape to show the election interference, the motive for election interference. And that's when it was like kind of solidified in my head. But yeah, to see it laid out like this is great.
And there was so much, if you remember too, there was so much going, if you look at a timeline of everything that was going on, because the other thing that happened around the release of that Access Hollywood tape was an hour later, WikiLeaks began dumping emails from John Podesta. And according to Jerome Corsi, who was a Roger Stone associate, Corsi told Mueller that, look, that was Roger Stone wanted the release of this information to distract from all this other stuff. So all of the stuff, if you look at that, I mean, there's somebody, you know, will go back in a more sort of, you know, the Mueller report can be dense reading. But if you look at that particular period in time, that one day, there was so much going on to get around and distract from things that, again, you know, the magic sauce of Donald Trump, his ability to escape any sort of like sanction for his bad behavior, things that would have ended the candidacy of any other person. There are all these little other things that managed to draw the media's attention away from the fact of this horrible, should be like disqualifying from the presidency statement that he made to Billy Bush. But all of that was going on in that October 2016 timeframe.
Yep, election interference. So we'll see what ends up happening. Like you said, man, it's going to be an interesting show next week to see where we're at and see if any of these pre-trial desperate moves to delay or adjourn in some way are at all successful. And, you know, we'll cover it for you. All right. We have a lot more to get to in other areas of the country and other investigations, but we have to take a quick break. So everybody stick around. We'll be right back. Hey, everybody. Welcome back. We have another group of patrons to thank. Thank you so much. Barton Wright, Naomi Wolf, Jason Ryan, Jan Collins, Stacy S., Lindsay First, Denise Woodson Ofria, Jurgen Rabutska, Joseph Archidiacono, and Tiny Blue Dot in the rural Red Sea of Florida. Thank you so much for listening. Thanks for contributing. You make this show possible, and we couldn't do it without you. All right, let's head down to Fulton County. Because Trump has filed a motion to dismiss his case based on First Amendment grounds, right? Argument being, if I lie to the public about election interference, I'm covered by the First Amendment. That's his actual argument. And this has been denied. Judge McAfee has denied that his case be dismissed on First Amendment grounds, saying, after considering the extensive briefing, the argument of counsel, and the indictment, the court finds these vital constitutional protections, First Amendment, do not reach the actions and statements alleged by the state, nor do the statutes themselves facially violate the First Amendment. The defendant's motions are therefore denied. After interpreting the indictment language liberally in favor of the state as required in this pretrial stage, the court finds that the defendant's expressions and speech are alleged to have been made in furtherance of criminal activity and constitute false statements knowingly and willfully made in matters within a government's agency's jurisdiction, which threaten to deceive and harm the government. During oral argument, the defendants posited that the speech at issue, even if false, was political, and that one cannot be prosecuted for falsity alone. However, unlike the statute at issue in Alvarez, which is a case that was cited, the state's allegations do not suggest that this prosecution comes solely because it believes the speech was inaccurate, and the prosecution does not result in merely restricting false speech. Instead, the indictment says that the defendants acted willfully and knowingly, and that they impacted matters of government concern. These are not legal conclusions, but issues of fact. Okay. Now, Trump has asked for permission to appeal this ruling. I'm sure he'll get it. But I don't think it's going to have much of an impact on what's going on behind the scenes right now. I don't think there's not even a trial date set here. So,
yeah, all to slow it down. And along those lines, Trump filed a motion to appeal the decision not to disqualify Fani Willis as district attorney. Well, Willis responded to that motion saying Trump's appeal, quote, reflects the applicant's dissatisfaction with the trial court's proper application of well-established law to the facts. Because the applicants have wholly failed to carry their burden of persuasion, this court should decline interlocutory review, unquote. Now, the DA's response came this past Monday, and we'll let you know how the judge rules when we know. I would be very surprised if the decision was, or if the motion was granted. I think this is entirely, again, to the point of like, just pure litigiousness to slow things down in an increasingly desperate way. We are seeing in Fulton County exactly what we were seeing in New York. And at some point that we're going to, I think, see in Washington, D.C. I don't know that we're ever going to see it in Florida, but, we'll see. 3 out of 4 ain't bad.
Well, you have to lay a marker down for to file a later appeal. So like if he didn't file a motion to dismiss on First Amendment, he wouldn't be able to appeal on First Amendment after his conviction. So you got to lay those markers down. So that's a lot of this, but it also, happens to also serve his interest in delaying things and drawing stuff out. I mean, he's got 13 motions or something down in Florida, and she's just now scheduling hearings on Nauta and De La Vera. She hasn't even gotten to the Trump motion hearings, and she doesn't even need hearings.
She hasn't docketed, a third to a half.
She's got a secret docket that we can't even see most of this stuff.
Insane.
Yeah, it's ridiculous. All right, now let's go over to Arizona because our good friends Biggs and Gosar are in trouble. This is from Betsy Woodruff Swan at Politico. Arizona investigators probing Republicans' efforts to overturn Arizona's 2020 election results have subpoenaed 2 members of Congress who were among Trump's closest Capitol Hill allies in the scheme. Remember the Green Bay sweep? The subpoenas to Representatives Biggs and Gosar, which have not been previously reported, ordered the 2 Arizona Republicans to testify before a grand jury. The subpoenas themselves, in conjunction with a series of other aggressive recent moves, show that Mays, who's a Democrat, has cast a far wider net in her probe than previously understood. like a lot of us were thinking they were just going after the electors, right? The Republicans who signed their names as duly authorized electors or certified electors, knowingly, falsely. But now, I mean, this is including Biggs and Gosar. So we'll see how far this goes, but it's a wider net than previously understood, at least through public reporting. Now, Mays appears to be nearing a decision whether to ask a grand jury to issue indictments in the case. And if she does, she'll become the fourth state or local prosecutor to bring criminal charges over the efforts by Trump and his allies in the fraudulent elector scheme. And, you know, this is interesting, Pete, because we talked about this a little bit last week when, she subpoenaed some other folks that are seemingly targets of the investigation and who said they would come in. I think it was Mike Roman said, I'm going to come in and I'm going to plead the fifth. And generally, you don't bring somebody into the grand jury that's going to plead the fifth because that could unduly prejudice the grand jury, because you're not allowed to take a negative inference from pleading the fifth in a criminal case. You can do it in a civil case, but you can't do it in a criminal case. And so to avoid even going near that kind of implicit bias that might attach to somebody pleading the fifth in a criminal case, they don't bring those targets in usually. They just indict them, right? That's, for a very long time we talk about, why hasn't Rudy been subpoenaed? Well, he's a target. You're not going to bring a target in. And so I think it's an interesting, from what I understand and from some public reporting and what some experts say, is that she's trying to see if she can get any of these guys to flip. But I would do that outside the grand jury. Now, if there is an appeal, Renato Mariotti said, if there's an appeal based on, implicit bias from pleading the fifth, that's a long haul. That is a hard appeal to win and probably won't be winnable, but you're giving them something to appeal on. So it'll be interesting to see how this shakes out.
Yeah, agreed. And I am curious too, and we've talked about this before, like to what extent the overlap between all the different states from Arizona to Georgia to Michigan and others, how much that overlaps with what Jack Smith is doing. Because it seems clear that what he's focusing on is very much Trump and trying to keep that simple and get that built for speed in a way that hopefully gets resolved before the election. Anybody's guess as to whether or not that happens. But I do have some question in my mind. When you see people like Mike Roman showing up again and again and again, it's clear that there may be violations of state law, but it sure would seem to me that when you have repeat people showing up in multiple states, that there are probably federal crimes that are implicated as well. So I am very curious to see, if and when Jack Smith decides to bring charges. We've talked and speculated about it before. Does he, if Biden's reelected, he understands that he has some time before he bumps up into statute of limitations issues. If Trump is elected, does he go ahead and charge these other people just to put that marker down, even if they're pardoned or it gets taken off the table, just so that information is in the public record? But it is seems highly unlikely to me is that you could get people who are showing up in all of these different states again and again and again. Not the individual electors, right, who are different.
Like Chesbro and
all the, right, and
Mike
Cleta
Roman.
Mitchell and Mike Roman and, Sidney Powell and all those people and Eastman and others that would seem to me to have some federal exposure. But I'm curious if we ever get there or not.
Yeah, people who aren't known unindicted co-conspirators in the Jack Smith Trump case, those 6 people who aren't those. But I think the people that were named are those people. And so we'll see first of all, how their testimony impacts what Jack Smith is doing. And like you said, when does he indict all these people? Because if Biden wins and Trump still hasn't gone to trial, there's no point in indicting all of these co-conspirators and having them file to consolidate with Trump and then pushing Trump's trial back. Like, get the Trump trial done, even if it's after the election, get it done. And then what I think Andy McCabe calls the mop-up cases, indict everybody else afterwards. Like you said, there's no chance of bumping into the statute of limitations. So anyway,
right.
My thoughts.
And speaking of one of those knuckleheads who shows up time and time again, let's talk about Rudy. This is from Matt Nahem at Law and Crime. The judge presiding over Rudy Giuliani's bankruptcy on Thursday granted a reprieve by declining to decide then and there whether the former New York City mayor should have to sell his $1 million Florida condo. But the jurist also issued a clear warning. The worst is very likely yet to come. Now, before Thursday hearing, Giuliani asked U.S. bankruptcy judge Sean Lane not to force him to sell the condo as he appeals the $148 million Georgia election worker defamation judgment that sent him into bankruptcy. Giuliani has maintained that the judgment was, quote, unreasonable on its face, unquote, and has expressed doubts that Ruby Freeman and Shay Moss suffered, quote unquote, any damages. Which it just makes my blood boil. But setting that aside, Giuliani continued arguing that ordering him to sell the Florida condo now, when in his view the judgment may be significantly reduced on appeal, would cause him irreparable harm. And in any event, he's already agreed to sell his Manhattan property. He also said he's, quote, working diligently to grow his broadcast income, unquote. Good luck with that. And he plans to use the Florida condo to do so, which would, quote, only serve to benefit creditors, unquote. Reuters reported that the bankruptcy judge did ominously forecast that lawyers representing the Official Committee of Unsecured Creditors, and that's the thing, like all in caps, the Official Committee of Unsecured Creditors, could lash out as harshly as one might imagine. Quote, the debtor may succeed in fending off this motion, only to be faced with far more draconian requests for relief in the future, unquote, he reportedly said, warning that Giuliani's assets may be pursued through other means. The Associated Press reported that the judge mentioned that the committee may seek the appointment of a Chapter 11 bankruptcy trustee, that is, a trustee who would, quote, manage the affairs of the debtor and make all decisions, unquote, about Giuliani's property, and has the power to propose a plan of reorganization. So again, this grinds incredibly slowly when it comes to, it infuriates me that Rudy says, no, I don't know that they suffered any damages, that he'd be saying that now after the trial and after everything that has come out. But I do think we're reaching the point where, you know, Rudy is captured. He's on the Rudy horizon, right? He's been captured by that black hole of dying destitute and in jail, and no matter what he does, he's not going to be able to escape the pull of his fate.
No, and every day sucks, and every single day, and the next day will suck more, and it will continue, probably asymptotically, until he shuffles off this mortal coil. All right, thank you for the Rudy update. got a little existential there at the end. Let's see, what else do we have to cover today? You know what? We still have more, but we do have to take one more quick break. So everybody stick around. We'll be right back.
Hey, welcome back. Thanks to Matt Thole, Paul Lagasse, Terry Stewart, Gail, OG Kristen, Alex Archer, Beth McLeod, Lauren Rapp, Marion, and everyone listening just lost the game. Thank all of you for being patrons. Thank you for, I'm sad to have lost the game, but hopefully...
Is that like a Rickroll type thing? Like, is it
I don't know, but hopefully there's another game in the future. But thank all of you for making this possible and for supporting the show. Couldn't do it without you, and really, really deeply appreciate you. So we ended the last block with Rudy. Let's go down Misfit Lane a little bit further and talk about Pete Navarro. Now, Pete Navarro has asked the Supreme Court to take another look at his request to avoid prison, filing a long-shot request on Tuesday that the High Court rarely grants. Now, you may remember that in an emergency request last month, Navarro asked the Supreme Court to let him remain free while he challenged his contempt of Congress conviction before the Federal Appeals Court in Washington, D.C. At that time, Chief Justice, not just any Supreme Court justice, but Chief Justice John Roberts denied that request on March 18th. Navarro showed up to prison the following day. Now he's filed this motion. Justice Gorsuch, I think, has this before him. I would be shocked beyond telling if he were to grant this. But Pete Navarro finding out that, prison life maybe ain't the life for him. But so sad, too bad. Got a few more months to go still.
Yeah. How's the commissary? I wonder if he's buying those Oreo packets. All right. Next up, a disciplinary panel in D.C. has found that Jeffrey Clark did violate the ethics rules for lawyers in his attempt to aid Donald Trump's bid to subvert the 2020 election. And the way this sort of works, from my understanding of watching the hearing, Pete, and I know you were watching it too, we were texting back and forth what was happening, is that this commission, the committee, right? A disbarment committee. It looks like a panel of 3 judges listens to the arguments, and they make a preliminary determination that if even one rule has been violated, that's their preliminary finding. And that's when they then ask both parties to argue, what do you want to do about it? And at that point, the bar disciplinary council, the lawyers who are trying to disbar Clark, they're arguing for sanctions, including disbarment. They want him to be disbarred. And so then they'll take all of those arguments under consideration and I guess make a recommendation. We've been waiting, I think, for the Rudy Giuliani recommendation for a really long time now. But that was in New York, so I think they might have a different process. But he's also suspended in D.C. And we were supposed to get that decision. It's been any day now for a year, I think. I don't know. It's been a long time. I can't remember. But it's been a long time. But anyway, basically Jeff Clark, Captain Underpants, is well on his way to being disbarred.
Yeah, and I would hope there's some introspection. I see the benefit of moving deliberately. I see the benefit in being cautious to make sure that there's strict and absolute fairness in the proceedings. But if the bar committees of these various states cannot take a look at this horrible, egregious behavior by attorneys that they are licensing, and not before the next election, where these same attorneys might be involved in the same sort of activities, decide whether or not they should still be members of the bar, it's crazy to me. I mean, we're coming up, again, literally coming up on 4 years, and we don't have permanent answers to my knowledge, on any of these folks. They've been sanctioned. Some of the Michigan attorneys have been, monetarily sanctioned. Alina Habba and others have been sanctioned down in Florida for a frivolous lawsuit. But when it comes to like permanent, final disbarment or any sort of punishment that's final, I don't think we've gotten there anywhere.
I think Eastman Texas, is the closest.
Not New York. Eastman's closest, but he's still pending, right, out in California.
Right. Yeah.
He's in inactive
status.
Denver, what was her name out in Denver? Jenna Ellis out in Denver, right? I don't know that that's even final. So again, it's I get it. I get the being fair, but at some point, come on. I mean, we're getting to the middle of 2024.
Right. What's a disbarment for, if not for these jackholes,
Yeah. Yeah, and speaking of jackals, John Eastman is asking the judge who ordered his disbarment to stay her order so that he can continue to work as a lawyer and fund his criminal defense. He has affidavits from clients. Get this, clients including Marjorie Taylor Greene and Matt Gaetz supporting his request. Eastman says he's already spent more than $1 million in legal fees related to his representation of Trump in 2020 and expects to face $3 million in total before it's over.
Now think about that. Think about a lawyer asking the person who just recommended he be disbarred to please wait so I can make money to pay for my other criminal trial in Fulton County. Right. Can you not disbar me? Because I'm a criminal. I need more time. Right. I need more money.
Yes, I'm a doctor. I'm a surgeon, right? And I accidentally amputated your left arm instead of your left leg. But you know what? Everybody, hold off. Don't pull my licensing because I need to keep practicing and doing surgeries to support my, defense
criminal
of my
meth trial for having a meth lab.
It's nuts. And again, yeah, of course he represents MTG and Matt Gaetz because that's it's the sort of quality clientele that he pals around with.
Oh yeah, absolute pieces of shit that just happen to be Congress people, and use that to their advantage. I am a member of Congress, so my word is important. No, it's not. Next up, let's talk about Congress, because from CNN, House Oversight Chair James Comer and Judiciary Chair Jim Jordan, the Jims, remember they accused the CIA last month of intervening, blocking a criminal investigation into Hunter Biden by stopping the IRS and the DOJ investigators from interviewing witnesses. And this is, Comer, the Jims based this on a whistleblower that told them that the CIA blocked this. Well, the CIA sent a letter just now this week saying, we refute that claim. And CNN has the letter. And it says, without confirming or denying the existence of any associations of communications, the CIA did not prevent or seek to prevent the IRS or the Department of Justice from conducting any such interview. The allegation is false. That's CIA Director of Congressional Affairs James Catella in the letter to the Republican committee chairs. So yet another nail in the coffin of the impeachment inquiry that has been dead on arrival, but they keep it open, right? They have to, because Trump needs a investigation open.
Right. And if it's open, they can continue to accrue losses, including one recently from the Justice Department, who declined to turn over audio of Special Counsel Robert Hur's interview with President Biden to the House Oversight Committee Republicans. In a letter to the committee, DOJ says, quote, the committee's interest may not be in receiving information in service of legitimate oversight or investigatory functions, but to serve political purposes that should have no role in the treatment of law enforcement files, which is, yes, absolutely 100%. They have the transcripts, right? They've got the text of what Biden said in his interviews with her and his folks, but this is entirely for show. And again, keep in mind that this request is coming from the same people who won't release the transcripts of behind closed door depositions, and they're the ones now demanding the audio for something that they already have, not a summary. They already have the verbatim transcript of the interview. So it's such transparent bullshit.
Yeah, we're not going to give you the audio that you can slice up and cherry pick and put out there. Hell no. No. Here's a transcript. Sit down, enjoy, have a cracker. All right. I thought I'd save this one for last. But you remember last week, there were a couple of Republicans who wanted to change the name of Dulles, the airport, the other airport in D.C., to Donald Trump International Airport. It's not obviously going to go anywhere. But I love this. And I think they read my Twitter feed over there in the House Dem cloakroom, because Rep. Jerry Connolly from Virginia and Jared Moskowitz, one of the funniest members we've had in a long time,
fucking funny, Democrat
from Florida, they introduced a bill to change the name of the federal prison in Miami, Florida, to the Donald J. Trump Federal Correctional Institution. Days after the Republicans tried to change the name of the Dulles Airport.
I love it. And by the way, to highlight the fact, we know FCI Miami, one of its newest inmates, the same Peter Navarro that we spoke about earlier. So Pete Navarro that would be fantastic. FCI Trump.
Yeah, I love it. I think we talked about this on the show. I think we talked about the Dulles thing, I think, on a bonus episode, and we're like, now they should name the prison after him. Yep.
And some people saying, oh, he doesn't need any federal correctional institute. He needs like Supermax, get like a legit, high security. And there, of course, there's a proliferation on Twitter of people like taking a prison guard tower and putting like the little Trump Tower logo on the side, which are hilarious. I've been seeing that one
for a while. Yeah. I mean, none of these are going to pass, but it was just funny. It was funny to me. And so I thought we would report on that. All right, that is our show. There was a lot that there's probably breaking news right now in Manhattan that we're going to miss. But we'll cover it on next week's episode. And then, of course, we'll see the patrons this weekend for the bonus episode. If you're a patron, you get twice as many episodes. So that's pretty cool. And I look forward to seeing everybody on the 20th. And boy, next time we meet for a public show, Pete, we could have jury selection underway in Manhattan. We'll see.
Yes, indeed. Coming fast and full of news. So we're going to bring it all to you. And I think, again, New York there's going to be enough stuff coming out of New York to fill each episode. But of course, we'll keep you up to speed on what's going on everywhere else. But it's, again, we've been saying this for a while, buckle in, but we are finally, it appears, about to be having a criminal trial underway.
Yeah.
Against the former president of the United States for the first time in history.
Phew. Yeah, everybody. All right, we'll see you next week. I've been Allison Gill.
And I'm Pete Struck.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts. dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.